I'm Jaimie Cavanaugh. I'm an attorney at the Institute for Justice. I live in Detroit. And like Kim Marie just mentioned, we've been representing Rose for about 5 years now. I've been with Institute for Justice for 5 years. This was my first case. I met Mary and Kim Marie about 2 or 3 weeks into the job. So yeah, this has a special place in my heart for lots of reasons. But I want to tell you a little bit about what we went through for the last 5 years, and then talk about some of the national implications. So at Institute for Justice, we care a lot about occupational licensing because we believe it's a fundamental right to go to work and provide for yourself and your family. And we don't like when the government steps in and puts unreasonable burdens on that right. Sure, there's lots of professions that it makes sense to license for true health and safety reasons, but then there's lots of professions where licensure doesn't make sense because there's no real health or safety harm, or where the licensure is so difficult and onerous to get that it doesn't make sense, the scale of the licensure doesn't make sense in response to the minimal harm that might happen. So we're always fighting these types of licenses for hair braiders, for people who want to sell food out of their home, cottage food producers. In Louisiana, they have a license for florists. That's the only state that has that license. We sued about that twice and lost. So these are hard lawsuits to bring. It sounds like common sense. And everyone in this room would agree that it sounds like common sense not to force every lactation care provider to be an IBCLC. We're talking about inclusivity here today. So we know we want everyone to show up at the table, and we want everyone to be able to provide care for mamas and babies. And we don't want to limit who can work to just one type of credential. But that's unfortunately exactly what the Georgia General Assembly was convinced was the right thing to do. So back in 2013, that was the first time that the legislature in Georgia considered this license that would restrict lactation consulting in Georgia to only IBCLCs. At the time, Georgia had an Occupational Licensing Review Commission, and it reviewed the proposal for licensure and recommended that the state should not adopt this license. They said it would harm families because it would reduce access to care. They said there was no real evidence that anyone was being hurt by unlicensed lactation consultants. And the legislature agreed with that proposal and voted against the licensing law. But a few years later, in 2016, the proposal came up again, and this time it passed, unfortunately. And so the law was on the books that would require lactation consultants to be IBCLCs to continue getting paid for their work in Georgia. The law contained exceptions for volunteers. So the state said, it's fine if you want to go ahead and do this work for free, but if you want to take home a paycheck, if you dare take care of your children doing that job, then no, you're going to have to go back to school for that. And we see that all the time. For instance, one of my cases was representing cottage food producers in New Jersey. New Jersey used to be the last state that prohibited the sale of cottage foods, and it was the same thing. If you were raising money for charity, having a bake sale, you could do that, at a church or for a nonprofit. But if you dared to take care of your family by selling cookies, then no, that was illegal, and you could, be fined for doing that. So it's really sad, I guess, in a lot of ways, how the government can step in a lot of times and prevent us from doing something that we should all be allowed to do. So the law was passed in 2016, but it wasn't set to take effect until 2018. We filed our lawsuit a few days before the law was actually going to start being enforced. So we filed the lawsuit. We asked the court to not let the law take effect. And this is one of the most critical moments, actually, as it turns out, in the lawsuit. Whenever we're talking to new clients about filing a new lawsuit, we have to tell them this might take years. And that ended up being true here, but it doesn't always take 5 years. But so one of the most important things that happened was at the very beginning of the lawsuit, we asked the court to rule that the Secretary of State couldn't enforce the lactation consultant license during the lawsuit, which would mean that everyone could keep working. And before the court even had a chance to rule on that motion, the state came to us and said, you have really good arguments. The attorney, I remember, literally said that to me on the phone. She said, you have really good arguments, so we're just going to agree that we won't enforce the law against anyone while the litigation is happening, while the lawsuit's still going. So thank goodness for that, so that everyone was able to keep working all this time while we, hashed out all the details with the court. So after that, we were in the court system. Our first ruling was that we couldn't actually have a decision on this lawsuit because Georgia doesn't protect the right to earn a living. That's what the trial court said. And we said, that's not right. So we had to go up to the Georgia Supreme Court, and the Georgia Supreme Court agreed with us and said, yes, there's a long history in Georgia courts of protecting the right to earn a living. So that took a couple years, and then we went back to the trial court, and we had to prove, now that we knew there was a right to earn a living, we had to show that what the government was doing, interfering with that right, was unconstitutional. Now, in most courts, in most states, and especially in federal court, it is almost impossible to show that a government restriction with the ability to earn a living or any type of economic regulation, it's almost impossible to show that a government restriction on that is unreasonable. And that's because the standard that courts use to review those types of laws, it's called rational basis review. And under that standard, the court can accept any justification that the government can dream up to justify a law. And in fact, the court can also supplement the government's arguments with its own arguments. So in our Louisiana florist case, the government had some reasons why it needed to license florists for health and safety. But the court didn't accept any of those arguments. It came up with its own reason to justify the law and said, well, we're gonna uphold this law because there's a chance that this protects people from infected dirt. Right. In some of these cases in federal court, they say that it's the plaintiff's responsibility, the person bringing the lawsuit, it's their responsibility to negate every conceivable basis for a law. So that means you would have to dream up every reason that could possibly justify a law and somehow provide evidence that none of those reasons could justify the law. It's almost impossible. So at Institute for Justice, making it easier to bring these types of cases is one of our big, long-term, overarching missions. So this case, while we knew it was so important to make sure that the hundreds, maybe thousands of people working in this industry in Georgia kept their jobs, the other part of this case that was so important to us was getting the court to talk about how it would review laws that interfere with someone's right to earn a living. So what this entailed was trying to produce a lot of evidence at the trial court to show why we were right that the law was unreasonable. Like I said, you're kind of guessing, right? You're guessing, how do I show that there's no reason that this law, that a judge could find this law reasonable? So we had 2 expert witnesses. We had a pediatrician talking about why it's important for her to rely on all different types of lactation care providers. We had another expert talking about the difference in scope between CLC and IBCLC. Ms. Serrano helped us by making some maps showing where CLCs were distributed throughout the state and where IBCLCs were distributed throughout the state, so we could show the spots where that would lose access to care if CLCs could no longer work. We had tons of sworn statements from Rose members, Rose users, mothers who used Rose services, and community transformers, and lots of different things like that, because we didn't know what the court was going to care about. And so at the district court level, we ended up winning, which was very exciting. We won there, and so the government appealed and said, we think that that's wrong, and so we got to go back to the Georgia Supreme Court a second time. And the Georgia Supreme Court upheld the trial court's decision. So we won a second time, and that's the final ruling now. There's no more appeals. So we've won. Yeah. Thank you. Yeah, the license is unconstitutional. Everyone gets to keep working. The government can't enforce this license. Hopefully they'll pass a bill to remove it from the books altogether. But the second important thing the Georgia Supreme Court did when it said this law is unconstitutional is that it said, we're not going to allow the government to rely on speculation anymore when it tries to justify a law. Because in this case, the government was saying, we want to create greater access for moms and babies to have access to lactation care and services. We want to increase access, but our evidence showed that this would decrease access to care. If you get rid of the majority of providers, you're going to decrease access to care. And there already isn't enough care to begin with. And the government, without actually offering any proof or data or numbers, said, no, we think that having everyone get this level of certification and having this level of education will help everyone and make sure that everyone gets the best care that they can. And so now we're making sure that everyone gets quality care. And the court said, no, in Georgia, we're not going to let you just say something you think might happen. We actually now in this case and moving forward, we're going to hold your feet to the fire a little bit more, and we're going to ask you to show what the real health and safety justification is for a law. So this makes Georgia a huge outlier and a leader amongst states that protect the right to pursue an occupation. And that's very, very exciting. Texas, Georgia, and Pennsylvania are the only states that have said we're more protective of this fundamental right to earn a living than the federal government. So our state constitution protects that right more than the US Constitution does. At IJ, we're hoping to export that win to more states. We have a case going on right now about hair braiding in Louisiana. We're absolutely going to be pointing to Georgia, saying Georgia applied this heightened standard of review. Louisiana, you should do the same thing. We shouldn't be requiring hair braiders to get a cosmetology license when they don't even learn braiding in cosmetology school. They already know how to braid. They've been doing this since they were kids. Yeah, exactly. And we've been doing braiding cases for 30 years, and we still lose sometimes. But we have managed to change the law in 34 states. So there are 34 states now where braiders can work without a license. Thank you. Yeah. So now that we won the case in Georgia, there have been proposals to license lactation consultants in lots of other states: Tennessee, New York, New Jersey, Massachusetts, Texas, and we watch those really closely, and we talk to legislators when we need to, and I was already able to submit some comments in Massachusetts recently and say they were considering a law to license lactation consultants, and it was a pretty restrictive law similar to Georgia's. And I sent in some written comments and said, you don't want to do this. You don't want to do what Georgia did and end up going through what happened there. And I sent the court opinion and told them all the reasons why They didn't want to restrict people from working. They didn't want to restrict people from continuing to help mothers and babies. And so, this is something that states around the country, I think, have been watching and really paying attention to see whether or not it makes sense to pass new licenses for lactation consultants and other professions as well. There's a lot of healthcare adjacent professions that are trying to become more medicalized, and that was something we focused on a lot in the lawsuit. Was we wanted to show that this isn't a healthcare profession, or not in the sense, this isn't brain surgery. We're not doctors. They're not prescribing medicine, nothing like that. We wanted to make the court really, really comfortable with the fact that they're not stepping into the shoes of a doctor or something like that, because courts are really conservative and hesitant to interfere with anything that they think is going to be actually medical. And so, we wanted to make sure that there was a distinguishing line there, and that's something that's going to be really important moving forward, I think, in a lot of areas, because the problem is, I might have alluded to this without saying it, but the problem is that once you create a license, you're locking so many people out from that profession. People who might want to work in that profession now have new barriers where maybe they have to go to school, they have to maybe pass expensive exams, they have to pay the government fees every year, and all that happens once you license a profession is you make that service more expensive for everyone, because you've limited who can provide that service, and so they can charge higher prices. So, at Institute for Justice, we support private certification, which is exactly what happens right now in the lactation consultant community. Everyone can choose the training that makes sense for them, and everyone works within their scope of practice, and that works in every state.
In the state of Virginia, we just became Medicaid reimbursable under doula services. And we're still in the process of training doulas and, coming under that reimbursement and all that. But one of the questions that my colleague and I had, and we talked about it when we were listening to you, was that one of the requirements, if that's what you want to call it, is a background check. And in our mind, we may have some community health workers who have been doing the work that may had some hiccups in their life. And now they won't, not so much that they won't be able to become a doula, but they won't be able to be under that reimbursable program. What is your take on that?
Oh, we sue about that. We don't like that. Yeah, of course. Yeah. We work on legislation to get rid of laws that will disqualify people from employment based on criminal backgrounds. We try to limit how states can use that information. We say that they shouldn't be able to look back more than, something like 3 years. I mean, we wouldn't care at all, but that's the type of thing that you can get into law is, try and say you can't look more than like 3 or 5 years. Like after that point, you shouldn't be able to look at anything. We have people that, for instance, learn how to become firefighters in prison, and then once they're out of prison, they can't get a license to be a firefighter. So because of their criminal record, that's the thing that's holding them back. So we sue about that. We don't like when laws use the words, you have to have good moral character, because no one knows what that means. And so an agency can absolutely use that arbitrarily you could have two people with the same background, and one could be disqualified and one might not be. We don't like those standards.
One of the measures of the strength of your argument is when you put it before the Council of Judges that is the Supreme Court as to how many of the judges side with your argument. So in Georgia, how many of the Supreme Court justices sided with your argument each of the 2 times you were there?
They were unanimous both times. So the second time we were there, one justice had to recuse himself because he was the attorney who argued against us the first time around, and now he was on the court, so he couldn't participate in the case, but everyone else voted unanimously.
Well, considering the language you talked about in North Carolina and really creating more equitable laws, to me that seems like a good solution versus, fighting in all these different states. Is there any way that like sample legislation or sample, laws could be provided so that those who are trying to do this and implement it equitably in different states can have that sample language by which to go with? Is that possible?
Yeah. I mean, I can share what we use. It's basically just you have to define a certification as something that's reimbursable, but yeah, I can share that. I think some of the problems with model language in this particular area are that every state's Medicaid standards are different, so that is more challenging. But, yeah, please come talk to me and I can share the language that we use for reimbursement. Yes.
Could you just mention the information that, or the response you got from the Secretary of State, who is the person we sued?
Yeah, so the defendant in the lawsuit, well, this is entertaining. When we first brought the lawsuit, it was against Brian Kemp, now the governor, because he was the Secretary of State at the time. He became governor, so now the defendant is Secretary of State Brad Raffensperger. And on the day the decision came out, the final decision from the Georgia Supreme Court, May 31st, the day the decision came out, Brad Raffensperger issued a press release congratulating us, saying he agreed with the court's decision and he was sorry that it took so long for this to happen.